Hi everyone, welcome to episode 3 of What's Up With That, Alex, where we sit around with Alex Boland and I ask him one somewhat difficult question related to separation and divorce. We're sitting by the fire today because it's -1 this morning in Vancouver.
Which is cold by Vancouver standards.
It is very cold. We're having a little bit of, I'm having a mocha. What are you having today?
I'm having a coffee black.
Nice.
As I want to do.
A straight up lawyer drink, that.
Right.
And we're wearing our sweaters today just to give a more relaxed feeling to what can be otherwise a pretty difficult topic to discuss. Right, so are you ready for today's episode, Alex?
Fire away.
Okay, my question today is this. It has to do with counseling. So I've got a friend who's going through a very difficult divorce, and he feels that his wife could benefit from some counseling as it relates to them dealing with the children. And he's asked her to go to counseling, and she's refused. So is there anything that my buddy could do to actually compel her to go and get counseling?
Yeah, there's the short answer is yes. The court in BC is empowered by the Family Law Act, which is the act that applies to all of us who eventually become separated, to make people do many different things that they wish they didn't have to do. Mm-hmm. And one of those things is counseling. One of the sections of the Family Law Act specifically empowers the court to require one or more parties, so litigants, or their children to attend counseling.
Okay.
And that is an order that is not infrequently made. It's not surprising probably to any of us that when we get to court and someone is acting not very well, the court says, geez, maybe we should do a little bit of work here. That being said, if your friend is keen on getting that counseling to happen, and especially if it's going to be any kind of intrusive counseling, anything prolonged or anything costly, he or she will need to lay a fair amount of evidentiary groundwork in order to lead the court into that decision.
And can you put that in plain language?
Yeah, I mean, basically, you need to be able to prove that it's needed, right?
Okay.
It's not just, well, we're not getting along, and so this person I think is crazy,
right,
or this person I think needs therapy.
Right.
You really need something, especially again, if it's going to cost a lot of money, or if it's going to take a lot of this person's time, or if it's going to involve a major intrusion into their private life. You're going to need some pretty significant evidence that there's a problem here. Usually that would come in the form of something we call a Section 211 report, and that might be a topic for a different one of these conversations, but essentially it's a report prepared by a psychologist where the psychologist would make various recommendations, and almost inevitably one of those recommendations is counseling.
Right.
And if there is a counseling recommendation made in that report, the court is very likely to follow down that road.
And what happens then if an order is made by a judge, but then the person who's subject to that order refuses to go to counseling?
Well, that wouldn't put that person in what we call contempt of court, which is not a very good place to be. Mm-hmm. It has the consequences for contempt of court range up to and including prison, but more likely they would have their parenting rights abridged in some way.
So reduced?
Possibly. I mean, it all would depend on the facts, but if there is a serious problem with this parent and the parent is not taking any steps to address the problem, then the court's options may include a reduction or a parenting time or changing the terms of parenting time.
Right. And
especially in high conflict alienation type cases, that can happen.
So contempt is when a person is ordered to do something by a court but then refuses to follow that order. They can be found in contempt of that order. They can
be found in contempt.
Okay.
It's a hard thing to do, to be found in contempt, or
right,
to find someone in contempt, but an open breach of an order that's intentional and knowing is a contempt of court.
So that's sort of like when I read in the paper about pipeline protests, and a court has ordered that protesters stay away from a particular area, but they still enter that area, and then...
That's a contempt of court, and the same sort of thing applies in a family law case. If a court has ordered you to do something and you're refusing to do it and there's no gray area about it, it's a strict no, then that person is in contempt of court. You know, I think the reality is that nobody's probably going to jail for not going to counseling.
Right.
But, you know, if you are in breach of a parenting order of that kind, you can't expect the court to help you. You couldn't go to court and ask the court to give you more parenting time, and quite likely it would be used against you.
Of course, I can imagine a spouse who's subject to, or ex-spouse subject to a counseling order, to avoid contempt, just going to that counseling session, but not really participating.
You can lead a horse to water, but you can't make it drink.
Yeah.
I mean, that is a fact, and that is nothing any court can do about that.
Yeah.
You can't force somebody into doing the right thing.
Yeah, so I suppose when you're the person who's thinking of bringing such an application to compel your ex into counseling, you have to think about that.
it's
is
a cost benefit. I
yeah.
mean, what is the cost and what is the benefit?
Yeah.
And that is a conversation, a difficult conversation, but a necessary one.
And we just had Allison Jones come in recently to do a divorce salon, and she's a therapist in town who I know you know well, and she was quite a proponent of this. She said that once you get people into counseling, even if they're reluctant, it can do some good. So I guess it's a per case basis. You have to assess that.
It really is, and all counseling is different, and different kinds of counseling will have different ramifications. Allison Jones has a certain amount of willingness to interact with the court, or her offices are willing to interact with the court, and so counseling with her could be extra helpful in the sense that it can render a little bit of accountability.
Right.
And somebody, an outsider watching on what's happening is helpful.
Right. And I'd also think that maybe if the children were involved, that might change the dynamic as well. And sometimes, Allison was talking about having sessions which involve the entire family. So maybe your ex would be more open to counseling in that kind of a scenario or setting. So just something to think about.
There's lots of ways of skinning the proverbial cat, right? So you could do counseling with the parents together and no kids, or counseling with the parents separately and the kids. It's really, it becomes sort of more of a therapeutic question and not so much a legal question. And right. I would typically defer to what the counselor thought was a good idea.
Okay. All right, well, that was a good yet quick discussion about counseling, and I appreciate your thoughts, Alex.
My pleasure.
I look forward to episode number 4, where I hit you with another really difficult question.
I'm looking forward to it as well.
Okay,
All right.
thanks. Bye, everyone.